Commissioners, James Miles, delivering counsel for the Commission. This morning we have scheduled cause number PUD 2015-00344. It's the application of the Honorable Sodi Clements and others. The relief sought in the application is to vacate and modify Commission Order number 341630 in cause number PUD 260 and redetermine issues following intrinsic fraud. That is the caption of the case. The full cause number in which that order appeared is cause number PUD 86000260. As you mentioned, Mr. Anthony, these matters are properly posted this morning for a special meeting of the Commission. The notice was posted at 3:30 p.m. Friday, October the 16th of 2015. That notice was filed in the case also on October the 16th. The applicant also mailed that notice to all respondents and other parties listed on their affidavit of mailing in which they filed in this case on October the 22nd. This special meeting is for the purpose of hearing 4 motions. Those are the motion of Southwestern Bell Telephone Company, DBA, AT&T Oklahoma for initial screening conference and hearing before the Commission in bank filed October the 2nd. Motion to dismiss of Southwestern Bell Telephone Company, DBA, AT&T Oklahoma, also filed October the 2nd. Attorney General's motion for initial screening conference and in-bank hearing filed October 2nd, 2015. And finally, the Attorney General's motion to dismiss, also filed October the 2nd. All 4 motions are also, by the way, shown on the Commission's in-bank hearing docket, setting them for hearing before the Commission in bank at this date and time. In accordance, one further notification that was given, I, in accordance with the Commission rules, caused to be mailed and emailed where email addresses were available, the notice of hearing those 4 motions to all the parties of record, and that was triggered because, as you know, in the screening conference rules, that is required. As following up with that, we memorialized that mailing and emailing by affidavits filed on October the 9th and then corrected and refiled on October the 22nd. In discussions with the parties, they are aware that the parties presenting their motions have 30 minutes to share between the Attorney General and Southwestern Bell. I inquired this morning. Southwestern Bell indicated they would be going first. And then applicants in response to a motion and Mr. Fent has also wished to make comment are also allowed 30 minutes. I'm unaware of any other parties that have requested time, but that is a possibility. I just do not know of any. And unless you have any questions, I believe these matters are properly before you, and we're ready to begin as you direct.
So we have 4 motions, 4 notices of hearing, 4 docket sheets posted on the door over there. We've got an agenda posting. We've got the special posting for the initial hearing conference that you mentioned. We have got this noticed.
Yes, sir. I think we're covered.
Very good. And mention the sign-in sheets.
Oh, yes, sir. I know they're to keep track of parties in attendance. There are sign-up sheets on the podium outside, attendance sheets, and
Thank you. We will ask for other appearances at this time, and I'd ask that you go a little bit slow. And if later you have a business card that you'd like to give to the court reporter, that would be fine. And if your last name is real complicated, you're welcome to spell it. Let's start with the applicants.
Russell Walker and Andrew Waldron, W-A-L-D-R-O-N, for the applicants, and Glenn J. Schrader Jr., S-H-R-A-D-E-R.
Jerry Fant, attorney for the applicant.
On behalf of the Oklahoma Attorney General, Adam Zilsaber. Michelle Craig, Office of General Counsel of Oklahoma Corporation Commission.
Good morning, Commissioners. Kurt Long, John Gray, and Thomas Ishmael on behalf of the Southwestern Bell Telephone Company.
Thank you.
Commissioners, Mike Velez on behalf of the Public Utility Business Corporation.
Let me see if any of the commissioners wish to make an opening statement. Was there anybody that planned to offer an appearance and give comment who was not recognized yet? I think, Mr. Miles, you covered it. Thank you. I did want to first of all, thank the Attorney General and the AT&T company for suggesting this hearing. I'd like to thank the other commissioners for working together to get it scheduled. It's one of our biggest challenges around here is get all the work scheduled. I'd like to review a couple of parts of the Oklahoma Constitution. They're all from Article 9 that pertain to the Oklahoma Corporation Commission. I'm jumping around and skipping some words. But under the oath of office, it has each of said commissioners will, to the best of his ability, I'm going to say his or her ability, faithfully and justly execute and enforce the provisions of this Constitution and all the laws of the state concerning the corporations over which the commission has jurisdiction. That was Section 17. Under 18 powers and duties, it says the commission shall have the power and authority and be charged with the duty of supervising, regulating, and controlling all transportation and transmission companies. The Constitution later defines a telephone company to be a transmission company. Doing business in this state in all matters relating to the performance of their public duties and their charges therefore, and of correcting abuses and preventing unjust discrimination and extortion by such companies. That's the wording from the Constitution as it came to us, I guess, close to 1907 at statehood. Other language in this section says that the Commission shall keep itself fully informed. It has the words in it that justice may be done. And under the organization section 18A, it says the concurrence of a majority of said commission shall be necessary to decide any question. And section 40 says influencing elections or official duty. I'm going to leave the word elections out, but read it. It says no corporation organized or doing business in the state shall be permitted to influence official duty by contributions of money or anything of value. I'd like to mention three issues that I think are key issues involving this Southwestern Bell 260 case. Number one, how much money is at stake? It's about the money. Is it $7.8 million or $100 million per year or something else? What is the revenue excess for the last rate case test year? This is a big dollar question. This is where the $16 billion number comes from, I think. Number two, we need to know, does the record now before us show that Southwestern Bell Telephone attorneys and officers engaged in bribery or fraud on the court or other illegal conduct, as may be indicated by federal and state court records, FBI evidence, or the Oklahoma Attorney General? My third issue is about trust in government. Will the Oklahoma Corporation Commission perform its duty? Will we, quote, ultimately determine, end quote, what Southwestern Bell Telephone owes Oklahoma ratepayers under a legally enforceable stipulation signed by both Southwestern Bell and the Commission staff? As we hear from AT&T, the Attorney General, and the applicants and others, I hope the commissioners will determine two things about this case. Number one, if the bribed vote is indeed voidable, can we and will we declare the bribed vote to be void? And the last item I have is, will we ultimately determine what the Southwestern Bell revenue excess is for 1989? Is it the $7.8 million based on assumptions, prospective numbers, and a bribed vote? Or is it $100 million based on actual data, a full audit, and a unanimous vote? I already voted no in the PUD 260 case to the $7.8 million figure, and I voted yes previously to the $100 million figure in the PUD 662 companion case. Mr. Long, I believe you have indicated that you will go first and start to share the 30 minutes, and you'll save some of the time for rebuttal.
Morning, Commissioners. Kurt Long on behalf of Southwestern Bell Telephone. I assume that you would want me to address both of the motions from Southwestern Bell.
Please.
The first one will take me about 20 seconds. We have asked for this initial screening conference because there are important jurisdictional questions that we think the commissioners themselves need to decide, and that's a threshold question that must be decided first. Now, with respect to our motion to dismiss, Commissioners, with all due respect, this is a frivolous case. The 1986 Bell rate case is closed. It has been closed for 20 years. You have no jurisdiction to reopen it. You have no jurisdiction to vacate the 1989 rate order that specified the reinvestment of $30 million. And you have no jurisdiction to order a refund. The Supreme Court has ruled on this 5 different times. This commission has ruled on this particular aspect twice. Even if you wanted to reopen this, even if you wanted to make refunds to customers, you cannot do that. You are barred from doing that. The law is crystal clear. Now, I want to talk about 4 reasons why you do not have jurisdiction. And any one of these reasons are sufficient grounds enough to dismiss this case with prejudice. First, the commission never had jurisdiction to order a refund in the first instance. We know that because in the appeal of the 260 case, the Supreme Court made that decision in Henry versus Southwestern Bell. It said that the $30 million in surplus funds generated by the 1986 federal tax reduction was not obtained by overcharging ratepayers, and the statute affords no authority for requiring a refund. Those are the words of the Oklahoma Supreme Court. This commission affirmed that in its understanding of that when it said in the 1997 remand order, quote, ratepayers are not entitled to a refund. Those are the words of the commission in 1997. And today, years later, the notion that there are billions of dollars to be passed out to ratepayers is simply delusional. Second, the commission cannot contradict the Supreme Court's decision in the Henry appeal. the appeal that affirmed the 1989 order in all respects. The commission can do nothing but observe the mandate that the Supreme Court issued to this commission. In Russell versus Black, the Supreme Court said, if this is not true, then indeed there would be no end to litigation in such cases, as judgments of the appellate court therein would be without the finality and binding force upon the parties. Indeed, that's the law. It's clear. And the commission has no choice but to follow it, even if you wanted to make a different decision. And it's especially true in this case that the commission must respect the mandate of the Supreme Court, because the Supreme Court has been asked and has 4 separate times said, we will not withdraw the mandate in Henry. We will not allow the commission to go back and relitigate this case. The mandate still bars the commission today. Third, even if the commission could consider this refund request, and I've told you why it cannot, the application seeks a prohibited retroactive rate making. Specifically, the refund of those amounts that were in before the commission and in dispute in 1989. The commission has no authority to correct past mistakes in rate matters. That's from the Turpin case. Those are the words of the Supreme Court, not mine. Past mistakes cannot be corrected. In Southwestern Public Service Company, the Oklahoma Supreme Court said that a rebate of excess charges arising in a prior period was prohibited retroactive rate making, and so is the request for refund that's before you. Now, the applicants say it's a legislative order. The 1989 order was a legislative order. That's true. It was a legislative order. It was a rate order. We all know those are legislative. And the applicants are saying, well, legislation can be changed all the time. You can repeal things, you can modify. That's all true. But that's only half the story. You change rate orders, legislative rate orders, all the time. You did it in Southwestern Bell. The rates have been changed from 89 repeatedly through today. We don't have the same rates we had in 1989. But here's the difference, and here's what the applicants miss. When you do that, you do it prospectively. You do it for the future. You don't go back and change the rates retroactively and say, oh, by the way, customers, you owe us more money, or in this case, by the way, customers, we owe you billions of dollars. You can't do that. The Supreme Court has said you cannot do that. And the applicants point to the rules of practice. They actually cite this in their application, 5-17-2, that authorizes a motion to modify a commission order at any time. Well, first of all, that rule does not clothe the commission with jurisdiction that you don't have. And you don't have jurisdiction here. Second of all, the applicants don't mention the Supreme Court rulings, particularly Southwestern Bell versus State, which was recently cited with approval in the Turpin case very recently. And in the Supreme Court said that if you're going to go back and modify an order of the commission, 3 criteria have to apply. First of all, it has to be done within a reasonable time. Second of all, it has to be done before there's an appeal. And third, it has to result in no prejudice. Well, within a reasonable time, it's been 23 years. That's not a reasonable time. Second of all, before there was an appeal in the 260 case, and the motion did not come before the appeal. So 3 strikes and you're out. They can't qualify for any of these. That $30 million was invested years ago. The customers have had basically the benefit of capital at Southwestern Bell's expense, not their expense. You can't go back and say, do-overs, let's refund all that now that the customers have had that benefit for years. Now, the applicants are saying that they're not bound by these rules. And let me just give you an example. Because they're legislative, and because the 89 rule was, order was legislative, they're saying they're not bound by it. Well, to use their analogy of legislation, if a citizen came in to court, or this commission for that matter, and said, you know that law that the legislature passed 3 years ago or 20 years ago, I didn't know about that. I wasn't a party to that, and I'm not bound by it. Wrong. They are bound by it. And all customers in rate cases are bound by the legislative rate orders that this commission makes. If it were not so, there would be utter chaos. That cannot and is not the rule. Fourth, the judicial standards that the applicants are seeking to impose here, the so-called bribed votes don't count. Those are from the Justice Corn cases from the 1960s Supreme Court standards, and they apply to judicial branches, that they apply to the judiciary, but they do not apply to the commission. Quite to the contrary, in Wiley versus Oklahoma Natural Gas, back in 1960s, the Oklahoma Supreme Court said, basically, biased votes do count. Now, the Supreme Court recently said the Wiley case has some, quote, obvious factual similarities to the Bell 1986 rate case. What did the Wiley court hold? It held the Supreme Court was, quote, without power to declare rate increases void based on allegations that the commission had been wrongfully influenced to approve them by contribution and favors from a lobbyist. So, biased and even bribe votes do count when it's a legislative order, and the 1989 rate order is a legislative order. Now, that may not be what you and I would have ruled. That may not be, if we took a vote, probably no one would like that ruling in this courtroom today. It doesn't matter. That's the law. And there are 9 robed people across the street that have the right to decide that, and not us here today. And you don't have the jurisdiction to apply a different standard. So is there no remedy for a bribe vote? Well, this is going to come as no surprise to anyone. We've argued this in the Supreme Court across the street. We've argued it to the commission before. Back in 1992, when the Hopkins bribe was first disclosed, the commission could have, within a reasonable time, asked the Supreme Court to recall its mandate and allow the commission to retry the case at that time. That didn't happen. That did not happen. It still hasn't happened today. It must have happened within a reasonable time for it to be valid. As a matter of fact, what did happen was the commission in 1997 specifically looked at, called for briefs, had hearings, looked at it in a deliberative manner with some of the best regulatory lawyers in the state, and the commission said, you know, we don't have jurisdiction to reopen that, and we're not going to ask the Supreme Court to do it because we think that there's reasons that the reinvestment that was ordered is the right decision. Well, 18 years later, you still have no jurisdiction to reach a different conclusion. So there's only one response, there's only one correct remedy here, and that is to dismiss this case with prejudice because you have no jurisdiction to hear it. I will yield to the Attorney General and reserve the balance of our time for related.
Let's see if there's questions, comments. You mentioned the Wiley case from the 1960s, which was an Oklahoma Supreme Court case. And if my memory is correct, a lobbyist attorney for the utility was paying sums of money to the general counsel, I believe, of the Corporation Commission. The figure of a total of $6,000 was used in one of the reports. Can you name who that person was that was getting that money?
I do not recall that from the court, Your Honor.
Well, I do recall. His name was Bill Anderson. He's the same lawyer that went to prison representing Southwestern Bell. If my information is correct, he was taking bribes in the 60s, and then a few decades later, he was giving the bribes. But it's just ironic that this Bill Anderson, he's very effective in getting things done, I guess. But it's the same Bill Anderson. So.
Yes, sir. And he went to prison, and rightfully so.
No, he didn't.
He's probably deceased now, so that's ancient history at this point.
Okay. I had one other question for you. Does Southwestern Bell wish to retract any of the testimony or statements that it has in this matter? And before, it looks like I'm trying to not give you the full story. I got 2 areas that I want to mention. In the 260 case, there was testimony by Bell from Mr. T.D. White, who is shown as the chief accountant. And on page 8 of his testimony, paragraph 18, he says, "I feel very strongly that it is not only wrong, but also inconsistent with the way this commission has regulated in the past to recommend a prospective rate adjustment starting sometime in 1989 based on 1987 data." He goes on to say, the 1987 data is simply too old to use for prospective rate changes in 1989 and beyond. The words I'm focusing on, oh, look there, he's talking about too old, but it not only says 89, but it says and beyond. And so I'm still inquiring about the stipulation that I mentioned earlier in related to that and almost quoting that testimony. The company, in its appeal of the report to the administrative law judge, once again, it's on page 8, paragraph F as in Frank, entitled "The Test Year." It says, staff used a test year ended September 30, 1987. The test year, which included only 3 months of actual tax data under the new Tax Reform Act rate, is clearly inappropriate. This amounts to a calculation for 3 separate test periods and beyond, based on only 3 months of actual data under the new tax rate. Does the company have any desire to say that they stand by that or don't stand by that? And while you're thinking about that, I'll read my second one, then you can choose. In I guess it's called a petition at the United States Supreme Court, entitled Southwestern Bell Telephone Company versus the Corporation Commission. The petition mentions the FBI's investigation and an indicted lawyer who formerly served Southwestern Bell. And that's Mr. Bill Anderson that we mentioned before. Here's the sentence that I'd like for you to consider. Does Bell wish to retract this statement or modify it in any way? Here's what you told the United States Supreme Court. Quote, "For the record, Southwestern Bell's position is this: any impropriety that may have been committed was not authorized by or attributable to it." Does the company think that statement is true?
Commissioner, there are always what-ifs in a closed case. I've been doing this in court and at this commission for over 40 years. And I can go back and post-mortem and go back through the record and find things that I wish were different, that I really liked. And there are decisions that I think are just wrong in the past. The point is, when a case is closed, it's closed. And it doesn't matter what I think, and it doesn't matter what Bell thinks. It doesn't matter what the evidence says, because the case is closed, the decision was made, and you have no jurisdiction to review it.
We'll let Ms. Dillsett come forward.
Thank you, sir.
My questions don't count against your time.
Thank you, sir.
Go ahead.
May it please the Commission. The applicants seek to reopen and redetermine the issues addressed in the PUD 260 order and disposed of by the Oklahoma Supreme Court in the decision we are all very familiar with now, the Henry case. No Oklahoma Supreme Court affirmed the Commission's decision to reinvest the surplus funds, and they specifically found that the refund was not authorized by law because the money was not obtained by overcharging ratepayers. The court continued, neither may the Commission's finding regarding federal tax laws effect upon Southwestern Bell be regarded as a declaration that a different rate should have been charged. In finding that, the Oklahoma Supreme Court was relying on Title 17, Section 121, which sets the standards by which this Commission can authorize a refund. The Attorney General's position in this case is very simple. There is no jurisdiction for it. Now, he raised additional grounds in his motion to dismiss, but we will be reserving those grounds until this Commission actually rules on whether or not it has jurisdiction. The Commission's jurisdiction over public utilities is prescribed by the Oklahoma Constitution as well as Title 17. While broad, it is not limitless. The Oklahoma Supreme Court addressed the limits of this Commission's jurisdiction over Commission orders in the Turpin case. In Turpin, the Supreme Court determined that Commission orders automatically become final after 30 days, and once final, that the Commission is without authority to vacate that order. Further, Turpin held it well established that the Commission has, and this is important, no power to entertain a rehearing or reconsideration request of a decision after it has been appealed to the Supreme Court. In making that decision, it relied upon the Southwestern Bell case from 1937, which is 1937 OK 461. Again, applicants seek reconsideration of the PUD 260 order. But as we've talked about, that order was in fact appealed to the Oklahoma Supreme Court on October 20th, 1989. Under Turpin, as well as under Southwestern Bell versus State, the 1937 Supreme Court case, this Commission has no jurisdiction to reconsider PUD 260 because it was in fact appealed to the Oklahoma Supreme Court and it lost jurisdiction at that point in time. The Supreme Court itself has thrice declined to hear the issues raised in the application. First in 1997, when the court issued an order stating that it had no appellate or original jurisdiction over Commissioner Anthony's suggestion to the court in the Henry case. A second time in 2010, when the court again issued an order stating it had no appellate or original jurisdiction over Commissioner Anthony's suggestion for sua sponte recall of mandate, which was again made in the Henry case. And a third time just last year, when it denied a request made by some of the applicants here to assume original jurisdiction over PUD 260. Turpin is controlling precedential case law that this Commission must follow. The Commission has no jurisdiction over PUD 260, and thus it has no jurisdiction over the application. Without the jurisdiction, the Commission has no choice but to dismiss the application. However, more persuasion is needed in the Oklahoma Supreme Court. Your attention is directed to the Commission's previous orders determining it no longer had jurisdiction over PUD 260. And I believe the Commission policy is a factor that this Commission considers in an initial screening conference. The Commission determined it no longer had jurisdiction over PUD 260 first in 1997 on the order on remand in the PUD 260 case, and again in 2003. The facts have not changed since then, and neither has the law. The first time the Commission ruled it was in the 1997 order on remand. Paragraph 6 of that order stated, quote, under the terms of Turpin versus Oklahoma Corporation Commission, the Commission lost jurisdiction of this case 30 days after the Commission's final order was issued. The Oklahoma Supreme Court has not withdrawn its mandate, vacated the Henry decision, and remanded the entire cause back to the Commission for a new hearing. Therefore, the Commission has no jurisdiction to modify or amend the issues affirmed by the Supreme Court because more than 30 days has elapsed since the Commission issued its final orders in 1989, and the Commission lacks permission from the Oklahoma Supreme Court to rehear the entire cause. That was a nod to the Turpin case. But the 1997 order went on further, finding that rehearing of the entire cause was neither warranted nor in the public interest. The Commission also noted in that 1997 order on remand that the Supreme Court specifically found that the surplus funds were not overcharges as contemplated by Section 121, and therefore that ratepayers were not entitled to a refund. The 1997 order on remand concluded with this statement: it is further ordered that the entire cause should not be reopened, and that no further hearings, proceedings, or orders are necessary with respect to this cause. Yet here we are again. The over 20 years later. The second time the Commission ruled that it lacked jurisdiction over this matter in 2003 was in cause number 2003-00250. The order dismissing that cause number first stated the Commission must give the PUD 260 order legal effect because the jurisdiction issue was litigated and decided. The Oklahoma Supreme Court decided the jurisdictional question in its order of May 9, 1997. The court's order responds to Commissioner Anthony's suggestion to the court, which raised the issue of the Hopkins bribe. The order declines original and appellate jurisdiction. After then citing the 1997 order on remand, again, this was 2003 order, stated even if the Oklahoma Supreme Court and the quorum of commissioners issuing the 1997 order on remand ruled incorrectly, the orders are final and unappealable, and they have become the settled law of PUD 260. PUD 260 has been finally resolved and concluded, and no further proceedings are found to be necessary, appropriate, or justified. Yet, here we are again. And while Commissioner Anthony did not sign either of those orders, he did state to the Oklahoma Supreme Court in his 2010 suggestion for sua sponte recall that this commission lacks jurisdiction of this matter. Yet, here we are again. It is abundantly clear that the commission, over 2 decades and at least 4 different commissioners, has set the commission policy on PUD 260 as closed. The commission should not, and indeed it cannot under Turpin, change that policy now. This cause should be heard by the commission. It should be heard now, and a determination should now be made that the commission does not have jurisdiction to hear the application. During his opening comments, Commissioner Anthony highlighted the need for public trust in government, and I just want to take a moment to address that. Commissioner Anthony is correct. The public, which includes individuals and industry in Oklahoma, do have the right to trust and rely on commission orders. It followed to its logical conclusion, however, allowing the application to go forward sets a terrible precedent in which all commission orders, even those that would date back to statehood, would be subject to being reheard, reconsidered, potentially overturned. That is not reliance. That is undermining the public trust in orders that are issued by this commission. And while, as I stated when I began, the AG has raised additional grounds for why motion to dismiss should be granted. Those grounds are reserved because without jurisdiction, this commission cannot move forward on the application. It must first determine and vote on whether or not it has jurisdiction of this matter before it can proceed anywhere else. And I will be happy to take questions from the commissioners at this point in time and also reserve the remainder of time for rebuttal.
You frequently, as did Mr. Long of Southwest Surveyville, mentioned the Wiley case. And the application in that matter, just to make sure I got the numbers right, on the second page, paragraph number 10, it said that the General Counsel, William L. Anderson, for the Oklahoma Corporation Commission, whose duty it was to represent the citizens of Oklahoma in rate cases before said commission, did during the years 1959 through 1966 receive substantial amounts of money from an attorney, agent, and lobbyist for the utility company. That was a gas utility company. Because Mr. Long and you in your written documents repeatedly made reference to 25 years, I just want to suggest that I think it's 55 years. Mr. Anderson started his public corruption, his either receiving or giving bribes a long, long time ago. And one of the things that I think it is sad when we talk about trust in government is that, yes, it's gone on for more than half a century. This caught the attention of the Oklahoma legislature. The Senate and the House had a joint resolution.
Commissioner Anthony, if I could be recognized.
Yes, go ahead.
I'm happy to respond to your questions. As I've said, though, the Attorney General does not believe that any of these issues are relevant until this commission has voted on whether or not it has jurisdiction of the application.
I understand that. Thank you. The results of the investigation was that it looks like that Mr. Anderson violated the canons of legal ethics, and they referred the matter to the Bar Association. But we know what happened sometime later. Here's my question for you. Has the Attorney General changed its position in this matter?
No, it has not. For over 20 years, it has maintained that this matter is closed and should not be reopened.
All right, well, I want to make reference to a few things. The Attorney General submitted a brief on June 10th of 1996, and it was in response to a request for legal briefs, which actually I issued. And on page 8, it says, quote, "There is ample legal authority for the Commission to reopen and rehear the merits of this cause." Now, I don't want to read this out of context because the sentence before that said, "However, with regard to the issues affirmed by the court, the Commission has no jurisdiction to address these issues absent the permission of the court." So it does say that those issues affirmed by the court are not subject to the sentence in the paragraph that I was reading. What I'm reading from the Attorney General today is different from what it sounds here, but let me go on and then you can respond to the...
Actually, Commissioner, if I could go ahead and respond to
Okay.
that. That might be easier for me what's fresh in my mind.
I understand.
So in those filings, again, the Attorney General did take the position that this matter should not be reopened, and I do not think the position that's taken today has been inconsistent. There was no jurisdiction for the Commission to hear it back in 1997 and 1996 when that brief was submitted. I believe if you read that brief, what it goes on to further say is that the appropriate recourse should the Commission acting as the Commission, which does require the Commission to have a quorum and vote, would be to send a bill of review to the Oklahoma Supreme Court to see whether the Oklahoma Supreme Court would take the matter back up. That is entirely distinguishable from the Commission now on its own determining it has jurisdiction over the matter. But again, that brief and all briefs filed by the Attorney General in this matter since it came to light has been that this matter cannot and should not be reopened.
Well, I'm still in the same section, and it's page 8, 9, and 10. And it starts off saying a series of Oklahoma Supreme Court cases with facts remarkably similar. It says where the Supreme Court justices had received bribes for a number of years. It's very pleasant about the history of Oklahoma. It then goes on to talk about Commissioner Hopkins was indicted and convicted, and he was convicted for accepting a bribe from Mr. Anderson in exchange for his vote. It says Anderson was counsel for Southwestern Bell. Now here's the sentence I'm focusing on, and frankly I think it contradicts what you just said. It says, under the authority of the Marshall case and the O'Neill case, order number 341630, which is the PUD 260 order we're talking about, was not constitutionally adopted, period. Thus, a new trial is authorized by law.
Marshall also says that even in such cases, if innocent third parties have relied upon that order, the fact that it was not constitutionally adopted will bow to the interests of those third parties. And as the Attorney General has argued in its brief, in this case there is substantial reliance by ratepayers and the public at large on the PUD 260 order, as well as the general alliance I mentioned before on commission orders in general, that they are settled and established and final, and all the parties can move forward with their business. However, the reliance issue, again, goes outside what the Attorney General's position is on scope of this hearing, which is that it's limited jurisdiction until this commission votes on whether or not it has jurisdiction of this matter. Until that happens, the commissioners cannot consider anything else besides the jurisdiction.
Referring to the Marshall case, which is the case that was just referred to in the Attorney General's brief that I had, I think it might be helpful if this Corporation Commission follows the example set by the Supreme Court in the Marshall case. And I would read paragraph number 29. It's only a sentence. It says, this court is and will be open to any litigant who can come forward with evidence that any decision was obtained by corruption and of any kind. I didn't read that very well. Who can come forward with evidence that any decision was obtained by corruption of any kind. That's paragraph 29. And 30 goes on to say that we find no statutory limitation. They go on to talk about the statute of limitations. We therefore hold the statute of limitations is not available as a defense in this proceeding. So all these 25 years you're talking about, I think the Marshall case does talk about things that are beyond normal time periods, and it's talking about bribery of judges or decision makers in the courtroom. But and you're welcome to comment more on that. Before us is the Leck case, the Optima case, the Hazel Atwood case. I don't find that you addressed any of those. The Leck case is an Oklahoma Supreme Court case that says if there's intrinsic fraud at the Oklahoma Corporation Commission, and I guess bribing one of the commissioners is intrinsic fraud, that you've got to go back to the Corporation Commission. So maybe that's what the Supreme Court was telling us. The Optima case is the same thing, and I'm sorry to say that I got overruled by the federal judge in the 10th Circuit, but they said the same thing. If there's intrinsic fraud, by the way, we have lots of fraud to keep up with around here. These are not the same Bill Anderson. These are other examples. It said that you have to come back to the Corporation Commission. Another just observation you're welcome to comment on. And with computers and Acrobat Reader, it's amazing how you can count words. The applicants in this matter used the word stipulation 24 times. The Attorney General and AT&T used it in their response 0. I think the stipulation is extremely important, as I mentioned from the get-go. And I think that Mr. Long and you both have said that these refunds of overcharges are inappropriate. I totally agree with that. I totally agree with the wording in the Henry case on it. Here is a brief from the commission staff filed in August of '89, and the headline here says, the commission's authority to require a refund is derived from the stipulation. It says, the commission has jurisdiction, this is page 2, the commission has jurisdiction to require a refund of excess of revenues, in question pursuant to the stipulation signed by Southwestern Bell on June 23rd, '87. Absent the stipulation, the commission would be unable to order a refund because Southwestern Bell was charging their authorized tariff rates at all times in question. I think this has been established a long time ago.
And again, Commissioner Anthony, those will all go beyond the jurisdictional issue, which is in front of the commission.
If the stipulation was adopted by a commission order and it was signed by the company, we have lots of stipulations that go forward, and it doesn't matter whether the case was bribed or not bribed or reopened or not reopened. Do you think that order and that stipulation, despite the fact it's quite old, is still in effect?
All due respect, Commissioner Anthony, that stipulation is not before the commission. Before the commission's motion to dismiss specifically whether or not this commission has jurisdiction over the application.
Well, if they mentioned it 24 times and you want to dismiss their application, I thought it might be, but I accept what you said. I got one other spot that I want to mention from previous filings of the Attorney General to see if you think they've changed. And this one comes from the Attorney General's motion to reopen the record. The first Roman numerals uses the word Southwestern Bell's representatives, illegal cash payments, illegal activities. It says the evidence attached to this motion contradicts and rebuts Southwestern Bell Telephone's denial of wrongdoing and shows that, in fact, the very highest level of Southwestern Bell's Oklahoma management was aware of such wrongdoing. As was urged in the Attorney General's pretrial and trial briefs, illegal actions carry with them certain consequences as a matter of law. It goes on to talk about, finally, despite Bell's claims that its wrongdoing is not relevant to this proceeding, justice demands that any decision in this case be rendered in light of the whole sordid factual pictures. It's talking about justice demands that Southwestern Bell not benefit from its own wrongdoing in this case below, and that's just above the signature block for the Attorney General, Susan Loving. Do you think your position has changed from what it was at that time?
To put that into context, Commissioner Anthony, that was a motion to reopen the record before the Oklahoma Supreme Court referee regarding Southwestern Bell's motion to recuse you from any further proceedings in the matter. It is not relevant to here as it was not submitted in the PUD 260 cause we are discussing today.
Is it,
Again, it's a jurisdictional question which must first be determined by this commission today of whether or not it has jurisdiction over the application.
thank you. You all have 10 minutes for rebuttal.
Other questions, Commissioner? Thank you so much for your time.
The movements are recognized. The applicants.
My name is Andrew Waldron, here with me today with Russ Walker. We've also brought 4 of the applicants. We have Mr. Proctor sitting here at council table. We also have Sodi Clemens, General Burpee, and Mr. Rod Norvell here to attend today's proceedings. And Mr. Potts, I'm sorry, I didn't realize we had Mr. Potts too. Today, I've been a practicing lawyer for almost 20 years. But today is my first time to ever appear in front of the Oklahoma Corporation Commission in any matter. I am basically a virgin when it comes to commission matters, and if I can use that word. So if you have lights that tell me when to stop, I don't know where they are. If I do something that's not procedurally correct, please excuse me and just correct me. Happy to be corrected. It is my honor to represent some very distinguished clients and citizens in the state of Oklahoma on a very important public matter. As the weather changes, inevitably I get allergies, so I'm still a little nasally and congested. If I don't sound right, please excuse that. As a preliminary matter, the applicants have filed a 27-page response to the motion to dismiss yesterday. It is intended to be comprehensive on all the issues that they have raised. I don't expect that you would have read it, obviously filing it yesterday. I would request that it be taken into account prior to any determination. The points made therein are probably stated more clearly than I can state them here today. I assume it's not necessary or desirable for me to read it to you. That would probably be cruel and unusual punishment for both me and you. At most, I intend to mention here today only some of the most critical points. We believe all the points made therein are important, however, and even if not discussed by me because of limited time, we request that, in effect, that I be allowed to revise and extend my remarks with the points included in our response brief. If you would permit me, I'd like to begin talking about bribery and corruption generally. If I ask you to clear your mind of all other thoughts, and just for a moment consider the names Adolf Hitler, Joseph Stalin, Benito Mussolini, Saddam Hussein, Osama bin Laden, and Timothy McVeigh, you would likely have an involuntary, visceral reaction just to thinking of them. Such is true for people with even minimal knowledge of history. Such is true for people whose primary source of world events is the pop culture magazine U.S. Weekly. History's worst war criminals, tyrants, and terrorists have earned mankind's universal loathing and hatred. If you've ever watched the A&E channel, or the True Crime channel, or if you've ever seen the TV show 48 Hours, or Cold Case Files, my wife watches every single one, you would likely get the same involuntary, visceral reaction if I used the names Ted Bundy, David Berkowitz, Jeffrey Dahmer, Charles Mason, John Wayne Gacy, or Adam Lanza. Thinking about serial killers and mass murderers likewise causes the same visceral reaction. For a great many Americans, an involuntary, visceral reaction follows from the names Enron, Tyco International, Bernie Madoff, MF Global, AIG, and WorldCom. For many years, I tried securities arbitration cases all over the country, in literally a dozen states, where I represented people who had saved their whole life for a good retirement, only to have it taken from them by means of big business corruption and fraud. Personally, I have seen that same visceral reaction, standing in their living rooms, watching them cry uncontrollably. Let me try 6 more names. Southwestern Bell, William Anderson, Glenn Glass, David Miller, Royce Caldwell, and William Free. I would submit to you that if you do not have the same visceral reaction to these names as you do to the names of Enron, Bernie Madoff, and WorldCom, then with all due respect, you don't really know, and you haven't really come to appreciate the fraud and corruption perpetrated right here before the Oklahoma Corporation Commission to the detriment of millions of hardworking Oklahomans. I should be very clear about this. I'm not saying that Southwestern Bell's misconduct here was as bad as Enron, Tyco International, Bernie Madoff, or WorldCom. I'm saying it was worse. I'm here today telling you that if Southwestern Bell's fraud and corruption had run any deeper, it would take a donkey ride to get to the bottom of it. Comments like this are made in all seriousness. Tyco International involved the embezzlement of $600 million. It's a big number. But by this standard, the current matter is 2,683% bigger. If you were to get on Google and just type in worst corporate scandals of all time, you're going to come up with varying lists done by various people, and pretty much on everyone's list, WorldCom is rated #1. Pretty much on everybody's list. WorldCom involved in accounting fraud of approximately $11 billion. By that standard, this matter is 46% bigger. As bad as Tyco, WorldCom, Bernie Madoff were, they were private frauds, defrauding private investors who made the choice to invest. They didn't involve bribery of public officials, subversion of the very institutions of government intended to protect all of us. They didn't involve the cheating of everyone, all of whom had no means to protect themselves. In that regard, the actions of Southwestern Bell were more like the actions of Benedict Arnold, a treasonous plot to pass the plans and surrender West Point to the British. It is a betrayal of the people, of the public trust, and of society as a whole. I'd like to first start by talking about what happened. In 1989, I believe Commissioner Anthony first became elected. And right off the bat, William Anderson, on behalf of Southwestern Bell, sought to bribe him. Commissioner Anthony is apparently incorruptible and immediately informed the FBI, and then cooperated with the FBI by wearing a wire. And over the next course of several years, Commissioner Anthony developed information that the FBI was able to use to uncover everything that occurred, to put some of the people in prison. The FBI investigates the matter. They employ traditional investigative methods. They go out and they surveil people. They got something called a pen registry, which is, they would track all the people that would call a certain person during a certain period, just getting their phone numbers and times of calls, just to figure out, who's running in this person's circle. They have the tapes provided by Commissioner Anthony, whereby numerous people, not just William Anderson, you also have Dave Miller and others, Southwestern Bell executives, not just their outside counsel, implicate themselves in all manner of corruption. And the FBI ultimately obtains a Title III wiretap. And you gotta hand it to the FBI. They are exceptionally smart in figuring out how do you uncover public corruption. You know, under a traditional method of investigation, you'd send out an investigator and he'd say, well, did you give a bribe? And what's that person gonna say? No. And then they go talk to the person who got the bribe and they say, well, did you take a bribe? And what's that person gonna say? No. So how are you gonna get to the truth? Well, the way the FBI got to truth is they went through the process of getting a Title III wiretap, which is the wiretap of a public official. And that is extremely hard to do. For reasons that are understandable, our federal government doesn't like to secretly record public officials in their business. So it requires the approval of the director of the FBI, of the Attorney General of the United States, and a court. They go through the process, they establish sufficient facts based on the secret wires that Commissioner Anthony had provided them, and then get permission for a Title III wiretap. Now that Title III wiretap is good for a small period of time, doesn't last forever. And so they gotta make it count. And so how do you get people to talk about what happened and to tell the truth unwittingly? Well, you get the Title III wiretap, and then you send out FBI agents all over the state to simultaneously ask questions. And what do people do when an FBI agent comes to their office and says, we're investigating an issue of bribery of a public official? What can you tell me about that? Well, they of course say no, and then they panic. Like all people who commit crimes do, they panic. And then they get on the phone with each other, and they said, I just got visited by an FBI agent. Holy mackerel. What are we going to tell these people? And they start calling each other. And one of the documents that we submitted in our response is this log of telephone calls back and forth. It's basically the FBI's evidence log on these telephone calls, and I'd like to go over a few entries with you if I could. Would it be permissible for me to pass them out?
You may approach.
There are other dates that are reflected in our brief, and I don't think I have the time to go over every one, but I'd like to, if I could, turn your attention to page 26. It's page mark 26, not necessarily the page in this exhibit, because I cut out all the pages you didn't need for this purpose. But it refers to March 14th, 1991, and it indicates FBI agents interviewed Dave Miller, Jewel Callahan, Mike Murphy. And then from that day forward, you see an intense amount of activity, calls back and forth, describing, well, what did you tell him? What are we going to tell him? Oh, good. What you told him is going to be consistent with what I told him. Oh, good. Thank goodness it'll stand up. They talk and plot about how they are going to lie to the FBI to cover up what it is they did. And what is it that they did? They bribed Commissioner Hopkins in obtaining the 260 vote. One of the things I particularly like, let's see if I can find the correct entry, but the FBI originally talked to, I believe it was Mr. Murphy, a state representative at the time, and Bill Anderson was so panicked that he then proceeded to call to try to get a hold of him over 20 times in like 10 minutes. How panicked do you have to be to try to call somebody 26 times in 10 minutes? You have to be pretty panicked. It's just shocking. It's just shocking. If you read the logs, it indicates what was pervasive conduct. It was Southwestern Bell's normal course of business to bribe, influence, and corrupt the Corporation Commission proceedings. It happened for many years. It happened for many matters. It was known and approved at the various highest levels of Southwestern Bell. So if we could, we'll get back to that. We're going to get back to it. The second thing I'd like to talk about is the AIG's misunderstandings in this matter. In 1996, they filed a specific brief that's already been mentioned earlier. It was a response to specific requests for information. And in there, specifically on page 8, they talked about a series of cases that are remarkably similar to the one at issue. That being the cases that involve the bribery of Justice Korn and other justices of the Oklahoma Supreme Court. They note that when that issue ultimately came up years later, that the court ultimately held that the bribery rendered the justice's vote null and void and set aside its previous decision. And that's because when you obtain a vote by bribery, bribery doesn't count. Those were 5-4 decisions. If Justice Korn's vote didn't count by bribery, then unconstitutionally they decided the case. And if they unconstitutionally decided the case, it had to be redecided. Even if the result was the same, you still have to redecide it to have a constitutional vote. They note that in the 260 case, it was a 2-to-1 decision. And if the bribe vote of Commissioner Hopkins were likewise thrown out, then this matter, the 260 matter, was not constitutionally decided. They then write on page 10 of their own brief in 1996 to the Commission, under the authority of Marshall and O'Neill, order number 341360 was not constitutionally adopted. Thank you. That is the point, that is the exact point we come to you today to make. It wasn't constitutionally adopted. It's not valid. If it's not valid, it has to be redone. Whether you reach the same result or a different result, I leave to you and your good judgment, but it has to be redone. In their brief, they're asked, they do articulate that they don't think the matter should be decided differently. They think that it's still in the interest to allow reinvestment. But what is it based on? It's based upon their review of the records. They're not experts. Do they cite any specific expert testimony to substantiate their result? The answer is no. Did they attach any documents or reference any documents which would justify their decision? No. In the Latin vernacular, going back 2,000 years, we'd call it ipsi dixit. It literally means he himself said it. It's the legal principle that something is supported based merely on the assertion that somebody said it. It is the legal principle of ipsi dixit that says the moon is made out of green cheese. What supports it? Ipsi dixit. There's no evidence that are cited. No evidence is cited. No experts are consulted. I'm not saying the Attorney General aren't smart people, but they're not experts in this area. What we are talking about is highly technical regulatory accounting of a public utility. It's not taught in law school in contracts, torts, or civil procedure. The American legal method by which we would test if something is true is by an evidentiary hearing, where you have one side who advocates for one position, another side advocates for another. That was not done here. If you had a lump in your chest, in your breast, for example, would you rely upon an Attorney General opinion to determine its significance? No. You'd go to the doctor and have some testing done. If you were trying to determine the cause of the Space Shuttle Challenger explosion, would you rely upon an Attorney General opinion to determine its cause? No. You'd have the very best experts in the country, engineers, figure it out. Trying to determine the super complex issues of highly technical regulatory accounting in a public utility matter, you don't rely upon the Attorney General's just opinion as to what it shows. You'd rely upon experts. And with all due respect, I can tell you firsthand, attorneys, by and large, aren't experts in that kind of a matter. But there is one person who probably was an expert, who was an attorney in such matters. And you want to know who that expert was? That attorney? William Anderson. One of the things that I think the commission should take special note of, if I may approach. I'm sorry, I just realized I put this on the top here backwards, so it's stapled in the corner, the bottom corner instead of the top corner as it should have. But again, we talked about how Commissioner Anthony was wearing a wire, secretly recording Mr. Anderson when he would come in to try to offer bribes to Commissioner Anthony. One of these occurred on August 3rd, 1989. That was approximately a few weeks before the 260 case was originally voted on. And you really have to hand it to Commissioner Anthony when, you know, he's got this guy who's coming in month after month after month trying to bribe him. And so Commissioner Anthony he's wearing a wire given to him by the FBI. He's going to try to get the man talking, see what he says. And so on page 13 of this particular document, you see Commissioner Anthony, his RA is blocked off there, but it's Commissioner Anthony. And Commissioner Anthony says to William Anderson, well, I saw your name on that 260 case, and of course, we're in there, in the courtroom. That was a lot of activity. Just a perfectly benign general statement saying, hey, I saw you in the courtroom. We sure had a lot of work going on that day. And it gets William Anderson talking. And he says, after it's all over, I'll tell you why I didn't participate anymore than I did out there. Well, of course, that's got Bob curious. He says, okay. William Anderson says, I'll tell you off the record why I did not. Bob immediately asks, why is that? So here William Anderson saying, I'll tell you later after this is all over, why I wasn't participating. And Bob says, well, can you tell me now, basically? And he does. William Anderson does. He cannot help talking about it. And he says the test year doesn't touch the top side involved in any of the issues. Bob says, huh? And he said, William Anderson goes on to say, of course, the issue in that thing is what happened from July 1st, 1987 forward, and should have taken test years from July 1st of 87 to June 30th of 88. But instead, they took a test year ending September 30th of 87 and tried to guess the rest of it. That's what they should have taken is the whole year when the tax went into effect. Bob then says, well, was that information available? And he goes, for 88? Yeah, it was available in 88. They could have had it. They could have been done with it. He goes on the next page to say, well, hell, you were just guessing, talking about the commission. Well, hell, you were just guessing on that thing, right? 2 years after that, and that's why I just told Bell, I'll just sit in there with you, but you're picking the wrong year. Best you can, but you got a lot of supposition and conjecture in the damn thing. That was William Anderson's analysis being recorded about what he considered to be the flaws of the 260 order. That it was based upon a 3-month test year, that it should have been based on a whole 1 year's test year that ran from June of 87 or July of 87 to 88, that it was just based on supposition, that it was inherently flawed. Was he right?
You've gone through about 22 minutes.
Was he right? You bet he was right. If you look at the 662 order, the order of the commission, if I may approach. This is an order that's hundreds of pages long, but I just have one page that is important. In the PUD 662 case, the commission had 37 days of testimony. It was just a hugely, horribly long record. And after considering everything, including all the actual data for 1989, which was that final test year, they determined that the revenue deficiency or excess, in this case it was an excess, was $97,446,984. They then applied some other factors that I couldn't explain to you if I tried, and came up with a subtotal of $1,100,557,297 for the year 1989. That's how much excess revenue Southwestern Bell generated in 1989 above and beyond with the existing proper rates. Well, what did the 260 order case say? Under the 260 order case, using that flawed data that was referenced by Mr. Anderson as recorded in the transcript, the number was $7 million. The difference between the two, $93 million. That's how far it was off. It was off by, I don't know, 1,400%. That's pretty off. Our position is pretty simple. Number one, you have the legislative power. In fact, you have the duty and responsibility to uphold the Constitution. The legislative power includes the power to pass any law, to do whatever is necessary, and if you have the power to pass a law, that inherently includes the power to pass a new law. The legislature can't be so restrained. That's one of the things we talk about in our brief. We have the fact that bribery is wrong, and that the bribery here is indisputable. It was proven beyond a reasonable doubt. It can't be contested in this matter. We have the fact that there was excess revenues miscalculated. This isn't about the $30 million. In fact, you could decide, hey look, you're arguing that we can't undo the $30 million decision? Fine, we won't. We'll only look at the other excess revenues that apparently were incorrectly calculated and do something with that. But obviously, excess revenues were grossly miscalculated. And then finally, you have the principle of justice itself. It's a four-piece puzzle. Do you have the power to correct it? Is it warranted that it should be corrected? Was something wrong done? Is the correction worthy of being corrected? And is that the right result for the people? You put together this four-piece puzzle, and it screams and calls and warns for action. I need to absolutely reserve the last minute for Mr. Fent, so even if I don't get to it, cut me off so that he has the last minute. But let me briefly address the arguments of Southwestern Bell and the Attorney General. First of all, that you never had jurisdiction to order a refund in the first instance. As we assert in our brief, that is a misread of the Henry decision. The Henry case was whether or not refunds were required. That was the issue they decided. And they said because it wasn't an overcharge, no refunds aren't required. They never addressed the issue of whether refunds were permitted. And whether it should be permitted or not is something that the Commission should decide in an unbribed vote. Number two, that the Commission cannot contradict the Henry decision. That would result in endless litigation. If you read the Henry decision, it specifically says they appealed on 7 specific issues. And here's our answer. Yes, no, yes, yes, no, yes, yes. On those 7 specific issues, one of the issues was not, does bribery make the vote unconstitutional? That wasn't considered. One of the issues was not, did they absolutely get the 260 number right? That wasn't appealed. One of the issues was not, can we correct this? Of course you can correct it. Those issues were not decided on the appeal. We've cited authority. It's the Parker case. There's a long line of cases, more than I can talk about now, but it's all in our brief. And the principle is that the settled law of the case doctrine only applies to issues that were actually or necessarily decided. It doesn't apply to any issues that weren't decided. The case was remanded. The commission is free to say, hey, look, there's a new issue that has come up. And because that new issue has come up, it compels a different result. Number three, that what we are seeking is impermissible retroactive rate making. That is clearly not correct. We are not asking that you change the rates retroactively at any point in time. The fact is that under the existing rates, because there was a change of circumstance, namely corporate taxes rates went down, they then got excess revenues. They do not just get to keep it. At the time, they were a monopoly, a regulated monopoly. They are only allowed to have a certain earnings on their capital, a certain percentage. And if they generate excess revenues, even if they charge the proper rates, something has to be done with that excess revenue. It has to be refunded, it has to be reinvested, something has to be done with it. We're not asking you to retroactively change the rates, we're asking you to correctly determine what were the excess revenues. And this commission's 662 order, done after 37 days of testimony, shows that the 260 order got it wrong. Because that order was obtained by bribery, it must be done. And now we can use that as an opportunity to get it right. And we should. It's in the interest of the ratepayers. Number four, that judicial standards provide that bribe votes only don't count in judicial proceedings. You know, that's not what the Wiley case said. The Wiley case said that legislative acts can be declared unconstitutional if violative of the Constitution, if repugnant to the Constitution. Here we have a specific constitutional provision that says a corporation doing business in the state shall not bribe a public official from his official duty. An interesting fact is that constitutional provision was not considered in the Wiley decision. The appellants never argued it. Why they didn't, I don't know. But they didn't argue it, and the court never considered it and never passed on that issue. In our brief, we cite to a General Motors case that's actually a whole litany of cases that talk about how a legislature must pass a statute consistent with the constitutional requirements in both substance and form. If you had a circumstance where the legislature passed a statute, or supposedly passed a statute, it was signed by the Speaker of the House, it was signed by the President Pro Tem of the Senate, it was presented to the governor and got the signature. But then it was ultimately shown that in fact, the bill had never been properly presented, it had never been voted on by any representative. Would that be a valid statute?
So we'll wind up in about 1 minute, and then Mr. Fenton will have a minute, and then Mr. Long's got 2 extra minutes.
The answer is no. The answer is no. It's not a valid statute. In the GM case, there was a statute passed by the Oklahoma legislature that was in good faith relied upon by GM. Attorney General wrote an opinion on it saying it's a good statute. But then it later became known that the statute is in fact unconstitutional, that you cannot waive ad valorem taxes. GM built an entire plant here in Oklahoma City in reliance upon the validity of that statute and the Attorney General opinion that they wouldn't have to pay ad valorem taxes. And the Oklahoma Supreme Court said, I'm sorry, but the statute is unconstitutional. An unconstitutional legislative act has no force at all, and it doesn't.
Mr. Waldrop, I'd suggest if you keep going, we're just going to add your time to what Mr. Long is going to respond.
I'll try to wrap up in the next 30 seconds. I'm sorry if I
Do it.
So that is the basic point. Under the authorities we provided to the commission, it is clear that an unconstitutional statute is void of no force and effect, and it should be redone here. And I apologize to the commission if I've gone over.
Any questions for Mr. Walton?
Mr. Chairman, I would like to note for the record that my cursory understanding of these documents, I do not find them to be relevant to the actual decision that's before us. And so while I did receive the documents, I just wanted to state that for the record.
And there were so many motions given to us today and so many notices of hearing. I think I agree with the statement you're making pertaining to one of the motions. But to the extent we're also having the initial screening conference, then I think it has the last line of which says anything to consider that might expedite the processing of the case or so forth. Anyway, I think you raised a good point. That's not necessarily anything for you to respond to, but Mr. Miles, I'd like to ask you a question. There was a request earlier that their written response, which was filed yesterday, be taken into consideration as a response to the motion. Is that appropriate?
Yes, sir.
I thought so, and if there's no objection, then it's a part of the record. You file it in the court clerk's office, right?
Mr. Moss, can I ask you a question? Does that mean that the other party gets a chance to file some reply type brief? I mean, kind of help us out with the procedural aspects here. Because there was a motion filed, somebody replies to it. Doesn't that mean that you go back to the people that actually, those that filed the motion, and they get a chance to file, I don't know if it's called a reply or what the technical term for it would be?
I did review the rules prior to this morning's hearing. When we're talking about motions, the rules at 165:592 under subsequent pleadings. Any relief requested has to be by motion, as you know. The response to the motion is allowed, it's not required, and nothing within the rules provides that rebuttal, as you would have in briefs, etc., is necessary or even provided for.
Okay. Because I think the documents that were referenced, they weren't delivered to the offices because I never received any. I don't know if Commissioner Hyatt received any, but there was nothing delivered to my office.
My office printed them off the website, I think, or the imaging system that we have. Does the Attorney General or the phone company wish to have an opportunity to have a response brief to the response?
Your Honor, I think you have what you need to decide this case. You have no jurisdiction, and despite this nice little mini trial that we've just heard from Mr. Waldron, you still have no jurisdiction. So we have no reason to file anything. We suggest that the only thing left to do is dismiss this case with prejudice.
The Attorney General does not require a reply to the response. The pleadings are in front of the commissioners. It's clear that there is no jurisdiction in this matter. And the motion is before the commissioners today to vote on whether or not they have jurisdiction for this application. So the Attorney General adamantly believes that vote is required today to determine whether or not there is jurisdiction.
Mr. Fent, did you wish to be recognized?
Yes, sir. Just one
Please come to the microphone.
May I please the commission? I'm Jerry Fenton, attorney, and I represent Mike Reynolds, a former legislator who is interested in this case.
Your Honor, I'm going to have to object. Mr. Reynolds is not a party in this case, and Mr. Fent has not gone through the proper procedures for intervening on behalf of Mr. Reynolds. He gave his appearance at the beginning of this hearing on behalf of applicants. That would be appropriate if it's okay with the applicants, but it's not appropriate to enter an appearance on behalf of someone who's not a party.
Well, I'll be in my appearance just for myself, and the commission can hear me just as a person that interested in this case.
Only if it's public comment, Your Honor, because Mr. Fent is not a party in this case either.
Well, regardless of that comment, I got interested in the case a week ago, and I've preliminarily read the application, and I support the application. And I'm in the case to review U.S. constitutional and Oklahoma constitutional issues in this case. And I cannot comment on that until I do my research. But that's my primary principle, is U.S. Constitution and Oklahoma constitutional issues in this case. Thank you.
Well, I'm kind of overwhelmed by all the paperwork I brought with me this morning, but I did bring the commission rule on intervention. It's 165:5-9-4, intervention. and parties of record. Any person not subject to subsection D of this section, interested in the subject matter of a cause, may become a party of record by filing a motion for intervention, which shall be accompanied by a notice of hearing and set for hearing on the next motion docket. By the way, we're going to review 5. This is unbelievably cumbersome. But it is what it is. Set for the motion docket. Or as agreed to by the parties of record and the commission or the administrative law judge. The commission or an administrative law judge shall prescribe terms and conditions upon which the intervention shall be allowed. And then certain persons shall become a party of record by filing an entry of appearance or orally stating an entry of appearance at any proceeding regarding the cause. I think in here I think it's appropriate for the commission right here to offer any party to intervene and to have their entry of appearance. If you were the Attorney General, you got special mention. If you were a respondent, you got special mention. Okay. So, what's the question?
I think the determination of jurisdiction would need to occur before we take appearances from the public.
I would concur with that.
All right. And so let's keep under advisement. It's over my head at this point. So apparently, whatever you want to say can be public comment. We do have a public comment sheet, and today's hearing was posted for open to the public and on the record. So one way or another, do you have anything else you want to say?
No, sir. And if the requirement that I do other pleadings to enter appropriately in this cause, I will do that.
All right. 165, 5-9-4. Was there a public comment sheet that was, yes, there was. Who's got it?
Mr. Chairman, are we?
The question is, are we continuing
Are we
with?
posted for public comment?
Commissioners, Michelle Craig, Office of General Counsel. At this point, I think you need to take up your matter and whether or not you have jurisdiction to hear the matter. Then you would go to your initial screening agenda. You would have to determine whether this is judicial or legislative, and as we all know, public comment is not appropriate in a judicial matter.
Well, we have, Mr. Miles, all of those postings that we gave to the public. And here we are. And some of these, we'll read the words of the posting that Southwestern Bell prepared that has all 3 commissioner signatures on it. Here is the one filed October 2nd, requesting the screening. The 3rd paragraph says, notice is further given that all interested persons may appear and be heard. On the notice of hearing that Bell filed the same day regarding the motion to dismiss with all 3 commission signatures, it says, notice is further given that all interested persons may appear and be heard. And then, when it goes on to talk about relief, it says that the commission shall issue such orders and grant such relief as it deems fair, reasonable, necessary, proper, equitable, whether or not specifically prayed for in the motion. So that gives you quite a bit of latitude in that regard. And then you have the provision of the initial screening conference, which has the explicit words that the conference will be conducted as an on-the-record proceeding open to the public. And then it says, we'll convene to consider, and it's got 1, 2, 3, 4, 5, 6, and number 6 is any other matters that may assist in the disposition of the cause. Now, we used to have a whole lot of initial screening conferences. We hadn't had so many in recent times, but that's the wording of what it says. And so I think that public comment was invited. Oh, at the bottom of the agenda that we put out every day, it says, all persons are invited to attend. These are public utilities. So,
Commissioner, if I may clarify, inviting the public to attend does not mean that they get to be heard on the record. If this is a judicial matter and you allow public comment, which is posed by parties who are not represented by counsel, who are not parties to the action, they are merely interested parties or persons, you run the risk of destroying the integrity of the proceeding and having it tossed down on appeal. And I'm sure that none of the parties who have paid counsel to be here today would like to see that risk.
thank you for that word. I know what you're talking about very well. J.C. Watson, I got slapped down. Mr. What was that gentleman's name? Mr. McCall from the Panhandle, and John Reeves did to us just what you said. Mr. Long, if my reading of your filings is that you were emphatic that this is a legislative matter, is this a legislative matter?
Well, the 1989 order was emphatically a legislative matter. The 260 rate case was emphatically a legislative matter. Today, we're here on a claim for refund. It sounds judicial to me, but I don't know that you need to even get to that because I don't think you have jurisdiction to go there. I suggest that you might want to rule on that first, and I respectfully would request if you want to hear about 2 more minutes, I've got some rebuttal to what Mr. Walter has.
All right, why don't you do that? Is there any objection? And does the Attorney General's office wish additional rebuttal? Thank you.
Well, the commission still has no jurisdiction to proceed, and we heard a nice 35-minute historical recitation of a very sordid chapter in commission history, complete with name-calling, accusations, allegations, innuendo, and even some mean statements about the legal staff at the Attorney General's office. The fact of the matter is no amount of that kind of activity can clothe this commission with jurisdiction that it does not have. The matters in question were litigated 20 years ago. The guilty were punished 20 years ago. Rates were established 20 years ago. The Supreme Court reviewed everything, and the case was closed 20 years ago. It's still closed today. It will still be closed tomorrow. You have no jurisdiction to reopen it, and you've got, I respectfully suggest that you've got plenty of cases that are current, that are very important cases before you, and that you do not need to agonize over this case, which is ancient history.
Recognized.
Yes, please.
Thank you. May it please the commission. Nearly all of the applicants' quote response presented here today on the 2 motions to dismiss this matter that are currently before you was not actually responsive at all. It was in fact an ad hoc trial on the merits of their application, which, as Mr. Waldron himself pointed out, a trial would require a presentation from both sides, people taking an oath to make true and correct statements and give their testimony, and for exhibits to be presented and entered into the record for your consideration. That's not what we are here today for. We are here today for a ruling on whether or not the commission has jurisdiction of this application. Now, why it was not responsive, I do think it's worth referencing Mr. Waldron's comments about the Attorney General being incapable of evaluating matters in utility cases. The Attorney General has a statutory charge to represent ratepayers in all matters concerning public utilities before the Commission. And in fact, the Attorney General has consistently and fully participated on behalf of the state's ratepayers in rate cases, including PUD 260. This duty is the utmost importance to the Attorney General, as is his duty as the Chief Law Enforcement Officer of this state. As the Chief Law Enforcement Officer, he must uphold the law, which in this case is clear. There is no jurisdiction. All of the other issues are irrelevant until that determination has been made. And even Mr. Waldron's efforts to inflame emotions with reference to murderers and terrorists and scandals in private industry cannot change the law. The emotions cannot change the law. That's the purpose of a law, is to remove the emotions from it. There is no jurisdiction. Now, Mr. Waldron did spend a few minutes responding to the motions to dismiss. One of those included that the Attorney General has misread the Henry case on whether or not a refund was required versus whether or not it was permissive in this case. The Attorney General disagrees with that. I think the Henry case did fully and adequately address the issue of whether refunds were required under the statute. And I would simply point out that the Commission cannot act outside the scope of its statutory authority. And the statute for authorizing a refund is set in 121 of Title 17. And I addressed during my direct regarding the requirements that it be an overcharge or that there be a determination made by the Commission that a different rate should have been in effect at the time.
Are you claiming that the applicants are seeking a refund based on that statute? They didn't say that. They said they were depending on the stipulation. The Commission staff that I read to you from 1989.
With due respect, Commissioner Anthony, I'm addressing their response that the Attorney General misread the Henry case. That is the only thing that I'm addressing at this point in time. I'm not getting into the facts or the basis of their application. So again, Henry did adequately and fully address it. The Commission cannot go back and relook at this issue. Applicants also claim that they're not engaging in retroactive rate making, but instead that they're trying to correctly determine what the excess revenues were. However, they're asking for a refund to be issued, a refund resulting from surplus funds of 25 years ago. That would be retroactive rate making. And this is a legislative matter, and it would also be retroactive legislation, which legislation by its very definition is prospective in nature. U.S. Supreme Court precedent on that, which is cited in the Attorney General's brief. Now, I mentioned this on my direct, but it bears mentioning again, and quite frankly, again, which is that if you play out the consequences of the applicant's relief they seek here to reopen this case, it invites anyone unhappy with a rate case to ask for a do-over. Might be 10, 15, 20, 25, 35, 45, 100 years from now. It would be unlimited. And they could seek it for any reason. It might be because a new commissioner has joined. It might not just be ratepayers, as in this case. It might be the utilities themselves who are telling the Commission, hey, you guys got it wrong. We actually should be recovering more from ratepayers. The knife is going to slice both ways. And it would result in chaos. It would corrode the public trust in orders issued by this Commission. And it would entirely ignore the Supreme Court precedent set back in 1937 in Southwestern Bell v. State and affirmed again in Turpin that this Commission has no jurisdiction over an order which has been appealed to the Oklahoma Supreme Court. Thank you so much for your time and consideration.
Let's see if there's questions. I got a question. Have you ever heard there's no statute of limitation when it comes to fraud on the court?
With due respect again, Commissioner Anthony, this Commission is not sitting as a court, it's sitting as a legislature.
I just asked you a question. Have you ever heard that?
I certainly have heard that before, and certainly in my time before I was a lawyer.
Okay. Anything else from Mr. Long or the Attorney General?
The Attorney General
Okay.
The Attorney General submits that there is a motion before the commission for a vote on whether there's jurisdiction.
Thank you. We have the question as to whether or not we're going to allow public comment. I think we certainly gave a lot of notice on both the hearing to dismiss and the special, or the initial screening conference, but we get to make a decision. Are we,
I do not find that it would be appropriate at this time, and that goes against my instinctive nature to say that we should not have public comment. But I certainly do not want to do anything that would put the proceedings at risk by mishandling the process. And being relatively new to the process, I would certainly be willing to listen to any type of correction, but I do not believe that the posting properly allows for public comment.
And I've already said that I would concur in that. I would also note, these are motions. This is motions for legal arguments. This isn't the merits of a particular case, even if you looked at it in that regard. I also have concerns that, similar to Commissioner Hyatt, that I don't want to do anything that would create a situation that would, affect what we've already done today.
So what about the initial screening conference that was requested by both parties and noticed for this meeting? In some regards, I thought we've been having it, but we're not allowing public comment. This is the first public utility case that I think I've ever heard of that the public was not allowed to make comment. But I think two commissioners have indicated their thoughts.
Chairman, I do not find this to be I forget the wording you used, a utility, a rate making, what was the wording you used?
I said a public utility case.
Public utility case. I mean, this is a case, and certainly I want to give absolute attention to this. And I was hoping today to hear more from the applicants about the jurisdiction question. We did not hear a lot there, but I would assume that there's probably information in the document we received yesterday afternoon along that line. And I certainly want to give ample attention to that and make that decision first. And at that point,
Okay.
if we just do determine that we have jurisdiction, then certainly, as I said, it's my instinctive nature to allow public comment. And so it's very difficult for me to speak otherwise, but I do not think it's proper at this point.
I thought I was hearing the Attorney General in the last few words spoken encouraging us to have a vote today on their motion to dismiss. Does anyone want to have a motion on the motion to dismiss? Or do you want to take this under advisement?
I would like to take it under advisement and take the time to review the documents we received yesterday.
Okay, I would support that position.
As would I.
Okay, great, but I have a few more things to say. Now, to be a commissioner, according to the Constitution, you have to be age 30, you have to have 2 years of residency, and you've got to be elected by the people. It doesn't say that you have to be a lawyer, but I've been doing the best I can. And I went upstairs and got this book on words and phrases. It's about fraud, or at least part of it is. And then I've been told that there's a very scholarly presentation by Professor Dwight Morgan of the University of Oklahoma College of Law. And it's called Delayed Attacks on Final Judgments. And just when you thought that 50 pages was enough, it's the first volume of a 2-volume. And I've spent a great deal of time reading it. Commissioner Hyatt, you may recall the other day we voted to vacate an order, and we discussed at that time some of the, let's say Mr. Campbell talked about that was appropriate in certain circumstances. All right, I'm going to go as fast as I can here. Here's something called Rule 60. This is from the federal side. It's a federal rule. And what we're talking about is if you have a final order, Mr. Long has described this as a final order, I think the Attorney General has too. I would just note that many of our cases end with orders that say final order. This one does not. Later there was a remand order, which some characterize as the final order. It doesn't say final order, it says remand order. I'm just as a layman trying to read the best I can. Okay, back to the Federal Rule 60. Or even from Professor Morgan, there is no question that the law leans towards finality. It leans towards not relitigating things and getting some answers. But there are things like a delayed attack on final judgments. I know I'm jumping around. I'll do the best I can. I didn't know some of the things that would be brought up. I've submitted so many documents and affidavits and so forth, but I need to cover one thing. Within about a year and a half ago, the FBI let me listen to some of the tapes. They wouldn't let me have them, but I listened to them. And that was the basis upon which I had the accuracy of those sworn affidavits. That was about a year and a half ago. So if 2 years is some kind of limitation, there is new information and parts of the story that are in both of those affidavits that was done with that time frame. I didn't give all those details. Now I'm back to Rule 60. Yes, there's supposed to be finality of judgments. No, there's not supposed to be such uncertainty. It says here, grounds for relief from a final judgment or a final order. Oh, that sounds like what we're doing here. It has 1, 2, 3. 3 is fraud. Now, the General Counsel's office, get this, at the federal level, they have abandoned the distinction between intrinsic and extrinsic fraud. I'm not sure that applies at the state level, but we know the order on remand talked about extrinsic fraud. And this case that has been brought by these applicants is the first time I remember anybody telling me about intrinsic fraud. If it was at the federal level, they'd say, don't waste your time on that distinction. And right here it says, number 4, if the judgment is void, and then it talks about timing. There's been a lot of talk about 20 years and 25 years and so forth. Yes, it has some timing. And it says a motion under Rule 60 must be made within a reasonable time. But then it goes on, and then it says, other powers to grant relief. We're talking about people that are faced with a final order that are looking for relief, and it gives as a special consideration fraud, and if the judgment is void. And it says, the rule does not limit the court's power. In other words, you can grant a time extension. And number 3 under that provision says to set aside a judgment for fraud on the court. Now I apologize to all the learned attorneys here, but as I read through all this material, there are different categories of fraud. Some of them would get you more relief than others. Some are really bad, and I'm sorry that it gets into some awful stories that have happened in the history of the United States. If you get a witness and the Ku Klux Klan drags him out of the courtroom just as he was heading to the witness stand and they murder him, that's called fraud on the court. If you falsify an affidavit, if you forge a document and give it to the judge, or like in the Optima case or the Leck case that involves orders at the Oklahoma Corporation Commission, then you got to go back to the Corporation Commission. Those are called intrinsic fraud. They're parts inside the court. Notice the order on remand of this commission, in this case, talked about extrinsic fraud. Now, moving back to these categories, bribing a judge is like about as bad an offense. If you lie to the administrative law judge, maybe you had a bad day that day. But if you bribe the judge, that is about as bad as it gets. But there's one thing that's even worse than that, going from my understanding, it's if an attorney in the case bribes the judge. You know, what's the whole system supposed to be about? And there's cases on this. And Michelle, you'll have to back me up. I did get your book. It's even got this supplement, and it has sections on fraud on the court. And I got some old cases. You told me some of them were old. Great. This case now isn't federal. It's state, and it's called Miranda versus Miranda. And it says here, this is kind of the zinger. The significance of a finding of fraud on the court is that it eliminates the time restriction for bringing a motion to vacate a judgment. Now, I'm influenced by that, and I sure as heck would not vote to dismiss this case today under these circumstances. And since we're going to take it under advisement, I'll save you the burden of having to hear about the other outstanding reading that I did. I've got one more topic, though. Hey, people pay me a salary. They're supposed to get something for it. Okay. Here's some newspapers just within the last month or two. This is September 27th. That's not so far ago. It's September 18th. The tribes just got $1 billion settlement. And you know what the wrongdoing or the claims were? It says the first two involving contracts between 1989. Oh, that's the date of the bribe in the Oklahoma case. So here's a group that it took them, whatever that is, 25 years to get their $1 billion. Here's one from Exxon, lost $1.2 billion, and their little problem of cheating people on their minerals goes back to 1982. Sometimes these big cases take a long time. And I'm sorry that Cox Cable people have been running these old movies, and this isn't just a movie, it's a true thing. I looked it up on there's this Klan member named Byron Dilla Beckwith. And I'm sorry to say that he has military service. And Mr. Allen, I'm glad you're here today, sir. And I appreciate you serving as an Army officer during a time of war. Thank you for being here. Your entry of appearance was made as well. Anyway, this gentleman knows how to use a high-powered rifle with a scope, and he assassinated a civil rights worker in his driveway so that his wife and 2 children came out. I don't know if you've ever seen the movie called Ghosts of Mississippi. Well, he was tried by an all-white jury in Mississippi, and they had a hung jury. A few years later, they tried him again in Mississippi with an all-white male jury, and they had a hung jury again. And then 25 years after he murdered this guy, they tried him again, except it wasn't an all-white male jury at that time. And he made a little bit of a mistake because he went to Klan meetings and started bragging about how he had murdered this civil rights worker and that no jury in Mississippi would ever convict him. Well, by that period of time, the FBI had informants and whatnot attending the Klan meetings. Well, it all caught up with them. Hey, there are lots of examples of where time has taken, and I know I'd get in trouble if I mentioned this. This book was given to me as a father of 4 daughters in 1985. That's about 20 years ago. And I bet Bill Cosby wishes that they couldn't bring up stuff 20 or 25 years on him, too. This stuff about it being old, can any, Mr. Long or the Attorney General's, Ms. Dilsaper, can you tell me, are any of these cases, if it's 5 years old or 25 years old, would it make any difference? You all keep throwing around the 25 figure like there's some magic to it.
Commissioner, it goes to the point you brought yourself, which is a court, a judgment. This is a legislative order. It is not a judgment. Making a statement in a legislative capacity, not as a court, for certain people. With all due respect, the murders that you are talking about are also very distinguishable.
I tell you that they are, but okay, let's try and go with what you're saying. If it's a legislative thing, like a utility rate case, that's what we all agree is legislative around here. That's the Prentice case from the United States Supreme Court. Is what we're saying that if you bribe the commissioner, you get away with it if the 30 days since the ruling in the Henry case applies. If it's 45 days,
Again, Commissioner, it's not the 30 days in this case, it's the fact that this order was appealed to the Oklahoma Supreme Court, the commission lost jurisdiction with that.
well, I'm glad you brought that up. That's where I'm going next. It's called the Henry case, right? And the Henry case, I'll give it to you from memory. The Henry case says, that's fine, mine's all covered up. Oh, here we go. The big bold letters at the top, all capital letters, both at the very top of the case and at the bottom of the case. It says affirmed in part, reversed in part. And then it says cause remanded. It doesn't say the 4 remand issues remanded. It says the cause is remanded to the commission for further proceedings not inconsistent with this pronouncement. The way I read that is that the cause was remanded to the commission. Notice it starts off and they say the issues, and they got them numbered 1 through 7. It wasn't all of the issues, it was only 7 of them. And they answered 1, 3, and 7, Charlie, as the affirmative and the others in the negative. And then some of those they remanded. If you read what it says, and then down here about paragraph 7, it says the state, that means the Attorney General, AARP, and Southwestern Bell each seek corrective relief from portions of the commission's order. And if you read the brief that the Attorney General put forward that I read part of earlier, it still said that we had jurisdiction for the parts of the order that were not affirmed. Yes, there were some affirmed. I don't want to touch them. Okay, I think, Commissioner Hyatt, that there's some reason to think this thing through. And I'm not sure I got an answer about is there a difference between 5 years and 25 years. Folks, it's been going on for 55 years. And there's more cases than this. By the way, this is the second of the big Bill Anderson bribery cases. And you know who the attorney for the first one was? It involved Dynamic Energy Resources and Creek Systems and ONG. You want to know who the attorney was? Because the commission failed, the commission staff, the Public Utility Division staff, with the encouragement of the commissioners, failed to do anything. So you want to know who the attorney was that brought the case? As I said, it was Russ Walker again. And you know what happened? Commissioner Hyatt, right after the case gets filed, they file a motion to dismiss. And we anguished over it, and several months went by, and we said, denied. We're not going to dismiss it. The Bill Anderson bribery influence at that time was not going to get away with a dismissal. And then what the company do? They had a motion to reconsider. And then we told them we weren't going to dismiss it then. Anyways, back and forth, back and forth. And then finally the company said, we admit no guilt, but we'll make a $48 million benefit to the ratepayers. Now, I don't want to exaggerate. There was more than one fuel adjustment clause, and it was hard to pinpoint how much of it, but I'm guaranteeing you more than $10 million went to the benefit of, and it's a sad commentary that the commission, and Brandy, this is no reflection on you because you weren't here at the time, the public utility staff wouldn't do it. And so then we had General Burpee, help me out. What's the highest rank of an enlisted person in the Air Force? Is it called a command sergeant major?
That's right.
Field?
That's right.
Anyway, we had one that was the director of our public utility, our consumer service division, and so he filed the case. He was kind of courageous. Okay, I know I've talked too much, but I'm trying to fill in for the public who didn't get their chance today. I apologize that oh, please, you'll be held in contempt. I apologize because I think my office led some members, the church group and so forth, to think that they would be able to give public comment. And so thank you for putting the matter under advisement. I do think this has been helpful to us. Do we want to do anything more with this?
Mr. Chairman, I would just like to clarify.
Yes, sir.
To your last point about the time.
Okay.
I just wanted to clarify and offer assurance that the passage of time would not influence my opinion, that in itself. I want to take a look at what information has been presented to us. I'm absolutely, as you are, appalled at what happened in the past, but you mentioned Brandy. Brandy and I were in college at the time. So I have some catching up to do.
Well, 55 years ago, I wasn't so old myself.
I do have some question as to whether we have jurisdiction, and that's mainly tied to the fact that it did go to the Supreme Court and the actions taken by the Supreme Court. I've not made a final decision on that yet, but we'll give it
Thank you.
diligent review.
Say, and I can tell that the Attorney General's office has spent a whole lot of time on this, and we appreciate that. We appreciate the company filing these motions so that we can deal with this in an expeditious manner. Is there anything further? If not, I think that we can be adjourned by unanimous consent, and the record will be closed. Thank you all for being here.